Hi, hello again. I'm Professor Darrell Jackson, and in this module, our lecture series, we're going to talk about business-to-business contracts. As they say in The Godfather, it's nothing personal, it's strictly business. Business contracts are often used in situations where a project needs to be completed by specific guidelines, or when using business, or when a business outsources work by hiring freelancers or consultants. A contract serves to protect the interests of all parties involved. Reduce it to writing and you won't have a problem, usually. Business contracts are crucial to the relationships between commercial businesses and our business partners. Contracts specify the terms of the agreements, services or products to be exchanged, and any deadlines associated with the partnership. Business contracts seek to prevent disputes and misunderstandings. A lot of misunderstandings come because there are like verbal agreements and handshake agreements and what have you. My best advice to you is to reduce it to writing, make it a binding contract, and specify everybody's rights and responsibilities on the front end. Let me give you some basic business-to-business contracts, essential terms and dealings that need to be a part of any agreement. Certainly, first and foremost, you want to label whatever document that you draw up as a contract or some type of agreement. You want to have those words explicitly in there so that everybody will know exactly what type of document they're looking at. Certainly, you want to list the parties involved in the contract. You want to separate the contract and or agreement into parts or segments that identify that particular paragraph's purpose. Write out the purpose of the contract prior to providing the details. What am I saying by that? Basically, you want to sketch what you're trying to do and then put it on paper. The purpose of this provides the services you want to know. If the purpose of the contract is to provide services or goods, you want to specify those in great detail and find out which party is supposed to do what in the particular written document. The purpose includes the services provided, the product created, labor exerted, or any other focus that pertains to the purpose of the present agreement. Some further business contract essentials indicate any monetary issues. This is where usually the train gets off the track. Who is supposed to pay what and when and why. So you want to explicitly indicate those, and they should be a particular paragraph probably by itself, probably the longest paragraph when you get down to the monetary issues. Identify all deadlines associated with the contract. Another big red herring in most contracts. Who's supposed to do what when? You say, well, is it a recurring contract or something that that it renews itself? What are the deadlines in this particular contracts? You want to explain the expiration date with any renewal terms. Many contracts expire, such as a lease agreement. The details of the expiration should be explained in detail. Consequences for breach of contract for both parties. Very, very important. Who was supposed to do what, when, why, how long this contract lasts, and what would make it go wrong. This is what is a breach of contract. Consequences often include payment for services not rendered, reimbursement for damages, and automatic termination of the contract. Confidentiality clause. This should be included. If any part of the relationship or partnership should be kept private, prevents either party from sharing details about the contract and business partnership. Termination conditions. Most contracts cannot be terminated unless there are some type of modification to the original contract. Specify the details of how the contract may be terminated and any consequences that might result or arise from the termination. And of course, please, by all means, include a signature line for all parties. Require all parties to the contract to sign the contract before anything has to happen or anything is enacted. This is what gives rise or makes it legally binding on both sides, the signatures on the contract. Contract negotiation strategies. You have a contract that you want to enter into with another business. How do you do this? You want to break the negotiation down into different parts. Use the I am only looking for what's fair approach. In other words, make yourself as a person who is trying to be noble in the whole contract negotiation series. Say, I'm only looking for my fair share, and I want you to get your fair share. That's called the I'm only asking for what's fair approach. Look beyond the negotiating parties to see who or what is the real interest or influence affecting each party. You want to know the person that you're, or at least try to get to know what motivates the person that you're negotiating with. If you know what their likes or interests are, you can better negotiate with them. If you know if you have some information about them, knowing what gives them the impetus to want to enter into this contract with you, that also helps too. Try and take control of the agenda, and from the onset by controlling the location, timing, topics, and pace. If you know for sure that you have information in your office or at your locale that will strengthen your position in the negotiation, try to have the negotiation at your office or have it at a neutral spot where you know that you can control these particular items in the negotiation series. That's what I mean by location, timing, topics, and pace. Make offers that always leave you enough flexibility to accept concessions from the other side. In other words, you don't throw your best offer out there, but you also have some wiggle room in whatever negotiation terms that you're bringing to the table, so that if you have to back down off some of them, you can also have some wiggle room there. Question rather than demand. Say, why is this important to you, or what would I need to do to get your consent on this, instead of demanding. Find points of agreement and end on a positive note. Now, this simply means that if you have negotiations that are going over a period of time, or you're breaking them up into segments, you always want to end each session on a positive note, or some type of agreeability, or have some type of agreeability rather, with regard to that particular segment of the negotiation. Do your research. The party with more research or information usually has more leverage. Use facts, not feelings. What do I mean by that? Successful negotiators separate business from personal, and also facts from feelings. Deal with ultimatums cautiously. If someone is throwing an ultimatum out there, take it or leave it, this and that, you must decide within yourself how much leverage you truly have and govern yourself accordingly. Breach of contract. I would be remiss in this segment if I didn't go into this with a little bit more in depth. Breach of contract, what happens if you sign the contract, everything's honky-dory, but then somewhere along the line, a problem arises. Somebody's not doing what they were contractually obligated to do under the contract. In contract law, a material breach of contract is a breach, and breach simply means a failure to perform the contract that is so egregious. You have a material breach of the contract that is so egregious that it renders the agreement irreparably broken and defeats the purpose of making the contract in the first place. Some very important breach of contract considerations is either party being deprived of what is being bargained for. Can the non-breaching party be compensated for the loss? In other words, the non-breaching party is a party that's expecting something to happen. Can they be compensated one way or another? Can it be repaired? Can the damage be repaired? And these are all things that, I'm speaking of things that can avoid litigation, hopefully. What will the breaching party lose? What are the chances that the breaching party will fix things? If this person is tardy on a payment that was supposed to be on the 15th every month, and they miss it, they miss the 15th payment, technically they're in breach of contract. However, if they don't pay, or if this is something they've done before and they've made up, is it something that you really want to jump and go straight to court with, or is it something that you're going to work with them on? Technically they're in breach, but it's up to you whether or not you want to litigate. Did the breaching party act in bad faith is another consideration. Do you really want to, if they're in good faith, say, well, actually I couldn't get your payment to you, using the example of the 15th. If I couldn't get your payment to you, if I personally hand delivered all the time, but I'm in the hospital or something like that, I'm in good faith. Technically, I couldn't get the payment to you because I'm, laid up in a bed in the hospital. But I'll get it to you as soon as possible. Or I may have the payment with me in the hospital. I just couldn't physically bring it to you. So if you come out of the hospital, maybe I could give it to you. Those are the type of things. Good faith. Bad faith is I intentionally saying I'm not going to pay you. I'm trying to deceive you and prolong not paying you. So I'm acting in bad faith. Is the non-breaching party ready, willing, and able to perform? It could be something where you have a part of the contract you subcontracted out. You can't put together this particular project or the service until you get the other portions that were delayed, with no fault of your own. So you're ready, willing, and able to perform if you would have been, rather, if you had that particular item from a subcontractor. And last but not least, what does the contract say about the breach? It will govern, first and foremost, how the breach should be dealt with. And it's up to the person who non-breached as to whether or not they want to litigate. Let me speak now, I'll go over a few key contract terms. Costs and attorney's fees are fairly straightforward. Usually the person who is in breach or who has been found to be negligent in violating the contract will have to pay the costs and attorney's fees if it goes to litigation. Arbitration clauses are very prevalent in contracts nowadays, and it has to do with any disputes regarding the contract must be resolved through arbitration process or the arbitration proceedings. Choice of law. This determines which state's laws will be applied in the event of a litigation. Same with jurisdiction. It is specified in the contract to say that the state, it tells you whether which state and the county where the lawsuit must be filed in the event of a litigation. What is waiver? Waiver permits the parties to forego the right to sue for breach of a specific provision in the agreement without giving up future claims with regard to that same provision. Okay, that's waiver. Severability. Severability is very important because it permits a court to sever or remove an invalid provision in a contract and keep the rest of the agreement intact. Say, for instance, you put something that's not enforceable, a paragraph or any type of provision in a contract that's not enforceable by law. Well, that should not negate the whole contract because everything else you have in the contract should be enforceable. So under the severability clause, if the court can remove that position, that particularly invalid provision, and keep the rest of the agreement intact. Integration. This is the clause that says that the written contract represents the final agreement of the parties. Why is this important? Because most people who are entering a contract, particularly in a business situation, have a bunch of ideas that they've bounced around before they even reduce it to writing. Say, orally you said this, orally you said that. You want to integrate all of these into one final written document, and that's what integration does. So in other words, if it's not on this paper, we didn't agree to it, because this agreement is the final and exclusive inclusion of everything that we want to agree upon with regard to this contract. Notice describes how each party must provide notices to each other. In other words, typically, notice say you put down what what address or what phone number you want to be apprised of if the other party needs to contact you. Okay? Relationships provides either party, prevents either party from claiming a business relationship that does not contractually exist. In other words, if I contract with you, you're supposed to be an independent contractor for me, this does not make you an employee of mine. If I contract with you to exchange business services, this does not make you my partner in any way. And these are the things that a relationship clause will spell out. Whether or not you're an employee, whether or not you're an independent contractor, whether or not we're partners, or whether or not this is just a joint venture. We're not partnerships, because that gives a whole nother set of rights to some party under the contract. So you must specify what these are. Assignment clause. It affects the ability of the parties to sell or transfer the rights under the agreement to another party. If A contracts with B, and then B turns around and assigns his contract rights to C, then A is looking to deal with B. He doesn't know that B has in turn assigned his rights or responsibilities to C. So that can cause a very egregious problem. So the assignment clause will deal with those, whether or not rights and responsibilities are truly assignable under the agreement. Force majeure. Force majeure simply has to do with acts of gods. Agreement will be suspended in the event of unforeseen events. If, in fact, you entered a contract and you're supposed to deliver goods, let's say, for example, and a hurricane makes it unreasonable that you will be able to perform under that, then a force majeure clause will suspend those until those services are, you providing those goods and services until that act of God has been lifted or made whole, or remedied, Escrow. Sometimes we hear this term bantered about, and we talk about escrow. Most people think about escrow when they're talking about real estate services, but this is simply, it allows you to place trade secrets, payments, and other information into a special account, which can only be opened under certain circumstances. So it doesn't just have to be money that's escrowed. It can be all kinds of documents and or trade secrets and what have you, proprietary information. Okay, jury waiver trial, pretty straightforward. Simply waives your right to a jury and provides a bench trial only or a judge trial. Limitation of damages sets a cap or limits the type of damages that can be awarded in a contract dispute. The biggest of those being punitive damages. Usually their punitive damages are only awarded in a limited amount of circumstances nowadays, and so this will determine whether, by contract, whether or not that will be available as per your contract. Warranties, of course, are simply promises or assurances made by either party regarding the various contract obligations. Indemnity, one party guarantees that it will cover the cost of certain disputes brought by third parties. Now, these third parties are parties that are not people who are involved in your particular litigation. You agree to indemnify them or step into or take up their liability. Okay. In conclusions, most contracts do not have to be drafted in a fashion that is very complex. They don't have to contain a whole lot of legalese. They don't even have to be drawn up by attorneys, if you will. In fact, probably the more straightforward the contract is with regard to the contracting parties, probably the better it will be and the easier it will be to understand between the two, particularly in circumstances where you're trying to ascertain who is the breaching party or what have you. Two elements that you want to make sure are involved in a valid contract. All parties need to be in agreement, first and foremost, and secondly, something of value must be exchanged. That can be cash, services or goods, or even a promise to exchange one of the foregoing. But it has to be exchanged for something else of value. As usual, with all of my modules, if you require additional resources, you can reference Black's Law Dictionary Westlaw, LexisNexis, FindLaw.com, and LawInfo.com. I am Professor Darrell Jackson, graduate of Grambling State University of Political Science, and also Juris Doctorate from Southern University Law Center. It's been my pleasure to provide you with this lecture.